Yes.
May I please hold item number 37, Lordship, adjourned for the day, Lordship.
$37.
Lordship,
You wanted to be password for the day.
Lordship.
Pass 37. Password of the day is paid for by the council of the petitioner.
May I please, Your Lordship. My lord, I beg to mention item number 29, Your Lordship. I will be requiring some more time for filing the rejoinder. My humble prayer, my lord, it may be fixed any date, but it may be on 15th July. Item number 29 of today's, Your Lordship.
Mr. 17 July 2024 as paid for by Mr. and annexed in council for the petitioner.
Any date, Your Lordship.
May I pray before worship, item number 8, maybe password for the day.
8. Okay. Password of the day is paid for by the council for the petitioner.
Please, Your Lordship, my lord. My lord, I beg to mention for listing of a writ petition, Lord.
Give it to the co-pastor.
Registry.
Daily list item 1 for motion.
This last time also we disposed of similar matters.
My lords, wasn't disposed of, my lords, because subsequent developments, my lords, there was a resolution passed by the board, my lords, to enhance the pay for people who qualify.
That's fine.
Yes, ma'am. Whether or not the same covers the petitioner, my lords, I've sought instructions along those lines. I'm requiring some time, my lords.
Okay. Now the case and call for the petitioner. Mr. B. Chaudhary, standing counsel for the APDCL, seeks some more time to obtain instructions. Matter is adjourned today. Just
3 weeks, ma'am. In the meantime, notice can also be issued, my lords.
No?
Notice hasn't been issued in the matter.
Immediately, it was raised to the present situation. It will notice a motion written on 22/7/2024. Requisite extra copies of the requisition will be served on the government. Standing counsel for the APDCL within 2 days. List on 22/7/2024.
I'm deeply obliged.
Item 2.
May I please, Your Lordship.
What is the date of the order?
28/6/2023.
28/6/24. Okay. Contempt. Mr. S.A. Ahmed
Yes, sir.
for the petitioner. Take steps within 2 days and this shall not be about.
Obliged.
After 5 weeks. Notice they will take it.
Item 3.
What is the date of the order?
15/3/2024.
15/3/24. Okay. Mr. M. Sharma, counsel for the petitioner. Take steps within 2 days and this shall not be about.
Item 4.
Please, Your Lordship. Lordship, this petition is pertaining to non-consideration of the matter of the petitioner for appointment of compassionate ground, Lordship.
This 2015 matter, we are not entertaining. It will be dismissed.
Lordship.
2015, this is a matter of 2015 where your predecessor, your father died in in 2015,
Lordship.
9 years down the line.
Lordship, there are several grounds that he had applied on. So, Lordship, the SLC has rejected his petition, Lordship.
No, but
On
not,
the ground of 5% ceiling has already been met.
so how
Lordship,
do we find that 5% now? It would relate to the vacancy which was there in 2015. You can't make that exercise right now. We are giving an opportunity to address the court at 2 o'clock.
Lordship,
You find out the law and then address the court. We are not discussing it right now because you are a young lawyer. We don't want to discourage you, but you have to make a convincing argument at 2 o'clock. Because consistently we have been dismissing this with petitions where there is a delay. There are two reasons. One, there is a judgment of Supreme Court in the case of Devabrata Tiwari. And second is our own judgment of Achyut Ranjan Das, which says after 2 years it can't be considered. These are the two reasons we are dismissing it. Be prepared and make a submission at 2 o'clock.
Lordship, we have annexed one judgment of this honorable court, Lordship, where along with this petitioner, another the person also applied for on compulsory ground, Lordship, and the honorable court allowed this petition, Lordship.
You see, in this judgment, the two cases which I am referring to was never addressed. Because after this judgment, the Supreme Court has deprecated consideration of compassionate appointment after a long delay. That is the reason you make your preparation, then make your submissions at 2 o'clock. We are giving you some time. Prepare yourself.
Lordship, kindly after 2 days, Lordship.
After 2 days, okay. List on 12/6/2024 as paid for by the council for the petition.
Item 5,
Literally, we can't discourage young people. Young lawyers, we are not discouraging. They must be given one chance. Mr. Chaudhary, otherwise they will not get a chance.
Surely.
Yes. Item 5. Same thing. You just wait for some time. The council doesn't come away. As the same order. 5 after some time.
item 6,
Instruction wrongly. May I please your lordship? Lordship, in this matter, notice already been issued, lordship, wrongly listed for motion matters, lordship. So, lordship, instruction is awaited, lordship. So, lordship, kindly 4 weeks time may be given to file our affidavit, your lordship.
There's an interim order to extend that.
Yes.
But Mr. K. Chaudhary, senior counsel, assisted by Ms.
And Mahanta.
and Mansal and counsel for the petitioner. Ms.
J. Bora, lordship, on behalf of S. Doctor.
Ms. J. Bharat, and counsel appearing on behalf of Mr. S. Dutta, standing counsel for PWR, ENRD department. There's for some more time to obtain instructions. Next paragraph, as notice of motion has already been issued. Prayer for adjournment is allowed. Next paragraph. Interim order passed on 17/5/2024 stands extended till the next date of this thing. Next paragraph is on 19/7/2024.
Not technically, notice was not issued.
No, it was
actually.
issued.
Issued. Okay.
It was
An
issued.
interim order will be extended.
Highly extended. Notice returnable in 4 weeks.
4 weeks.
That is the order pass.
Oblige, Your Lordship.
Item 7,
Wait, please,
Yes.
Your Lordship, the petitioners were employee under the Assam Small Scale Industry Development Corporation. So they superannuated, my lord, and they were entitled to leave salary for 300 days. Now, your Lordship would be pleased to see the page 59.
You see, for this, you'll have to approach the civil court. Interest is something we can't grant in the writ petition. Your only prayer here is to grant interest on the delayed payment of area, what you call,
As
leave
well as
salary.
as well as the cost.
For that, the High Court will not issue that sort of writ petition. You approach the civil court.
Madam.
Interest is something, suit for interest is not.
In that case, my lord,
it's not
it
maintainable.
may be close with that observation.
Heard. This time I shake my counsel for the petitioner. You're from?
Yes, thus, my lord, for 234.
Oh, who is for one? And Kalita, standing counsel for Industries Department, representing respondent number 1 and 5. For 2, you are there. Who is for 2?
3, 4, man.
Huh?
I'm for 2, 3, and 4.
Mr. S. Das, standing counsel for respondent numbers 2, 3, and 4. Mr. R. Pujari, standing counsel for the Finance Department, representing respondent number 7. Who's for 7?
6,
Oh,
man,
sorry,
I
6.
can appear, man. For 7, I can appear, man.
Oh, 7 is last, right? Okay. Next one. It is noted that the substantive prayers made in the writ petition is for claiming interest on the delayed payment of 300 days leave salary as well as for cost. In the considered opinion of the court, the listeners do not have a fundamental right to claim interest as well as cost. Accordingly, the writ petition stands dismissed with liberty to the petitioner to oppose the civil court for the same. For the said period, which will be subject to law of limitation.
item 9,
Yes, we should notice. Heard Mr. M. Khan, counsel for the petitioner, who is appearing for the respondents. Corporation Department. Corporation Department. Is there? Finance and pension is there. You have a Corporation Department. Miss
G. Swami.
D. Swami, then counsel appearing on behalf of Mr. G. Bordole, standing counsel for the Corporation Department, representing respondent numbers 1, 5, 6, 7, and 8. And Mr. Arbor, president, standing counsel for the Finance Department, representing respondent number 2. Pension and Accountant General
SK Medi on behalf of SK Medi, A Parasar.
for Accountant General. Okay. For pension will be there, you will be there. Mr. J. K. Goswami, learned government advocate appearing for respondent number 3. And Miss
A Parasar.
A. Parashar, learned counsel appearing on behalf of Mr. S. K. Medi, standing counsel for respondent number 4. Next para. Having non-payment of pension of our retirement benefits, including arrears salary for the period from February 2016 to January 2024, the present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Because if extra copies of the writ petition be served on the government, state and departmental council in course of the day. Next para, the tendency of the writ petition shall not be barred for the concerned respondent authorities to examine the claim of the petition to disburse the amount if found due.
Item 10,
Lordship, in this matter, Mr. Y.S. Mandan is appearing, Your Lordship. Kindly pass over the matter for the
Just- just a moment. We are issuing a notice here. They are seeking regularization.
Yes, Your Lordship.
Make
No,
response.
he's already been regularized, Lordship, but
Already
regularizes section assistant. Now he is claiming regularization as subordinate engineer grade 2.
Yes, he has completed his qualification for that, Your Lordship.
But you can't be regularized in that post.
Initial regularization as section assistant, Lordship, but at that point of time, as he has qualified for the test, Lordship, training, that is why he was given promotion as works as subordinate engineer. And that is why he is claiming regularization to that post only, not as section assistant. Lordship, he should notice, Lord.
Notice
Notice.
issued, Your Lordship.
Your name is
F. Hussain.
Ms. F. Hussain, also to the petitioner, as well as Mr. T. Nayak, understanding also to the PWD,
1 to 4, Lordship.
representing responding numbers 1, 2, and 4. And for BTC will be there.
Superintendent engineer,
Don't get it.
Mr. Vikram Chaudhary can be there.
Vikram Chaudhary can appear, Lord. Please.
Mr. V. Chaudhary, standing for the BTC, representing respondent number 3. Next para. The the petitioner is seeking regularization in the post of sub-engineer grade 2 with all constitutional benefits. And accordingly, this petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Learned Department Council in course of the day. List Dr. Powers.
Deeply obliged.
item 11,
The matter party regarding the selection of the Gauvra and the selection of the Udon by the Deputy Commissioner.
No, now this, they have started functioning, the appellate authority.
My lord, yes, that part is right, my lord, but here this case, my lord, the earlier, the one person approached this honorable court. He was not a candidate nor a private person, my lord. On the allegation that this is not a revenue which advertisement was issued, my lord. But subsequently, it was clarified by the circle officer as well as Mandal, my lord. There is 2 lot Mandal, or on this area, my lord, lot number 3, there is 2 headmen. One is already appointed, another is post is vacant, and that was part only written, my lord. Part 1, that part was omitted, my lord. For that ground, my lord, the Deputy Commissioner and the circle officer, on the basis of this honorable court order, who was not candidate, my lord, issued, my lord, both the hearing was concluded, and all this report is not considered, and my selection was done, my lord. Actually, my lord, it was typingly mistake by the authority, my lord. The only that part was not written, my lord. Volume or a part. And that part, when that part was not mentioned, so advertisement was only that part was subsequently it was clarified.
Okay, then you should notice,
Yes, my lord.
but
An amendment, my lord.
Mr. Chalil and counsel for the petitioner. Uh, Also had Mr. S. Datal and its counsel for the respond number
And
one and
two.
1 and 2. And
I am
Mr.
free
M.
for
Bhattacharjee,
time, Lord.
government advocate, additional senior government advocate appearing to respond to 3, 4, and 5. Next paragraph. The grievance of the petition is that an advertisement dated 5/9/2022 was issued for selection for the post of Gaon Pradhan of lot number 3 of village number 1,
Barley, my lord.
Borali Mari, BORALIMARI, under ALITANDANI Moza. Full stop. However, midway of the sex selection process, comma, the selection process in respect of respondent, the petitioner number 1 was withdrawn. It is posited that there was an error in the advertisement by reflecting the name of village as Borali Mari instead of number 1 Borali Mari.
Yes, my lord. That part only.
Next one. If you notice a motion returnable in 4 weeks, requisite extra copies of the representing the Southern Rangad State and Department Council in course of the day. Next slide. The pendency of the regulation shall not be a bar for the
If
Who will
there is no
examine it,
starter,
Mr.
my lord,
Gupta?
they are now
who
contemplating.
will examine which Deputy Commissioner for the respond number 3.
3.
Sorry, Deputy Commissioner, District Commissioner Nagaon within bracket respond number 3. Examine the claim of the petitioner of the claim of the petitioner was asserting his candidature for the village number 1, Borali Mari, part 1. Next one, this topic folks.
My lord, we are completing the fresh and tender, my lord, advertisement. So kindly
Pardon me?
maybe stay, my lord.
Lordship, the
No, if it is there,
yes,
still-
concerned lot is
still-
not there, Lordship.
You can still, what do you call, participate.
My selection is done already.
Huh?
My selection is already done, my lord. Improved order, my lord.
No, I understand, you see, but there
My
is
lord,
a
the
difficulty.
status should be maintained. Otherwise, my lord, if they issue the fresh advertisement, my lord.
File an interrogatory application. If they issue a fresh interrogatory, they file an interrogatory
Yes.
application. Because today we
Yes,
don't have a
yes.
cause of action. And the second part is under 162C,
Yes, so,
question of
yes, that time.
employment, it's what's it called, appointment itself is a subject matter of appeal.
Lordship.
Hello.
Obliged to Lordship.
Item 12.
May I please? For the petitioner before your lordship was appointed as Anganwadi helper in 2007.
Will issue a notice.
Lordship. Pendency may not be my lord bar for upgradation if they think so.
Pardon me,
The pendency of this petition may not be bar with consideration of that matter. Because it is almost
that Mr. J. Panigar and counsel for the petitioner, as well as Mr. J.K. Goswami Leonard, government advocate appearing for the, you are appearing for all the respondents?
All the respondents.
Respondents. Next point. The petitioner claims to have participated in the selection process for upgradation of Anganwadi worker to, Anganwadi helper to Anganwadi worker in respect of Ikuri, Kekuri, Chapuri, Anganwadi Center, which was initiated in the year 2020. And according to this, petition has been filed under Article 226 of the Constitution of India, alleging that petitioner has been deprived of upgradation. Next, issue notice of motion returnable on due date after 5 weeks. Return on so and so. Requisite extra copies of the petition be served on the learned government advocate in course of the day. The tendency of the petition shall not be a bar for the concerned respondent authorities to bring the selection process for upgradation of Anganwadi worker to Anganwadi, helper to Anganwadi worker in respect of the Anganwadi center referred above. Yes, item 13.
Item 13.
May I please also, matter relates to suspension matter. Suspension matter,
Suspension.
periodical review has been made, my lord. And
Okay, we are issuing a short notice of suspension.
Yes, sir.
Heard Mr. M. Saranya, counsel for the petitioner, as well as Mr. R. Gogoi, Leonard, standing counsel for the,
Forest Department, all the
For-
respondents,
all the respondents.
all the respondents, Your Lordship.
Forest Department representing all the respondents. Next one. The continued suspension of the petitioner by order dated 11/11/2021 is assailed in this petition filed under Article 226 of the Constitution of India. Next one. In view of the long suspension being being settled, issue notice of motion returnable on 21/6/2024. Requisite extra copies of the petition be served on the Learned Department Council in course of the day. Next one. List on 21/6/2024.
I always.
Item 14.
Notice including the clear to the board.
may it please, Your Lordship.
Yes.
Lordship, by this application, my lord, I have challenged the order of removal of the petitioner, my lord,
I'm issuing notice.
from service
Heard Mr. R. Islam and counsel for the petitioner.
for legal aid counsel.
Huh?
I'm for legal aid counsel.
For
Legal aid.
legal counsel, legal aid counsel appearing for the petitioner. The order dated 6/9/2018 by which the petitioner was removed from service, as well as the order dated 29/1/2019 by the appellate authority, thereby dismissing the appeal. a departmental appeal on the challenge in this petition filed under Article 226 of the Constitution of India. Next, issue notice of motion returnable on your date after 5 weeks. The petitioner shall take steps within 2 days for service of notice on the respondents by registered post with AD. Stop. Next, the Learned Legal Aid Council is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, list on students.
Item 15.
Yes, faculty.
Wait.
Versus Honorable Court Administration issued an advertisement.
I'm issuing a notice
Lots
at this stage. Mr. Monta,
Yes, madam, I am representing 1 and 2.
Mr. R.P. Kakutil, Senior Counsel, assisted by Mr.
AD.
Mr. A.B. Dale and counsel for the petitioner. As well as Mr. P.J. Monta and Senior Counsel, assisted by Mr. A. Barwar and counsel. Representing the respondents.
All the respondents.
One post may be kept vacant, Lordship. There are 4 posts that are still admittedly there on record.
No, in fact, as per the practice followed here, once the posts are there, it doesn't get filled up. It will be a next recruitment. So there's there's no waiting list to be for being filled up.
Then I'm well secured, Lordship.
Because of the fact that once they're appointed, their 1 year compulsory training starts. So there cannot be a midterm enrollment. That is the normal practice. But if it happens, you file an interlocutory application.
Lordship.
It happens. So the non-selection of the petitioner was on incorrect assessment of the written examination. You are also claiming that you should be considered as a regular candidate, not as SC.
As a recommended candidate, Lordship.
As an SC. No, SC.
SC candidate, Lordship.
You are not considered an SC candidate.
No, I've been as SC candidate only. Though in the recommended list, the last SC candidate, which marks is here, would be lesser than marks I have obtained if this mistakes have not been done.
5 marks, then he will get more marks than the last candidate of the SS.
No, but then.
Yes,
that
the
is something
evaluation
we
is
can't-
fast.
That is something we can't examine because the last candidate is not before us.
No, we are
Yes.
not this time because since the post are lying vacant, we are not,
Oh,
we don't want to
okay.
disturb the position last candidate.
Okay. The present petition has been filed in Article 226 of the Constitution of India. So the Learned Senior Counsel for the petitioner submits that 4 vacant posts are still lying unfilled. Next, issue notice of motion returnable on, give it date after 5 weeks.
I wait 24.
Requisite extra copies of the petition be served on the learned. Instructing counsel for the respondents in course of the day. Next one. Liberty is granted to the petitioner to file an interlocutory application in the event any process is undertaken for filling up the vacant place.
DPR.
List on students.
Oblige.
List. List on.
Item 16,
While I'm appearing as a legal aid counsel in this matter, I pray for notice for the present. There are four petitioners. We had paid for full back wages and terminal dues for two who had retired, and reinstatement and other contribution for two. The other two. But is it not necessary to go to the labor court? No, we had gone to the labor court. That's at page 45. What has happened there? We lost. Saving that. So after that, the labor court order is being challenged. Absolutely. Oh, okay. I was missing that connect. I understand. Heard. Mr. Hasbanik, legal aid counsel. Appearing for the petitioner. The legality of the award dated 24/5/2023 passed by the Labour Court, Guwahati, in the proceedings of. It is given that case number. Case and case U of the case 2 capital A within bracket numerical 2 bracket closed number 04 of 2021 is assailed in this requisition filed under Article 226 of the Constitution of India. I should notice a motion returnable on so and so. Same date 5 weeks. Requisite extra, the petitioner shall take steps within 2 days for service of notice on the respondent by registered post with AD. Registered would do, Milo. Registered would do. You will not record it. Next one. The learned legal aid counsel is at liberty to collect the postal receipt number and submit postal track report prior to the next date of the same. Distance was. Wait.
item 17,
Petitioner is the second wife of the deceased and petitioner number 2 and 3 are the minor sign-offs, daughter of the petitioner number 1. And petitioner number 4 is the son of the petitioner number 1 not. All the children are born arising out of the second marriage. So also clearing claiming for pensionary benefit of deceased husband.
Mr. Zakia,
Lordship.
the under the personal law applicable, it will be the first wife who will receive the pension.
Yes.
If you want a apportionment, you'll have to go to civil court. How can we, in a writ petition, direct the respondent to share the money with you? He's not amenable to the jurisdiction of the court.
I am entitled to get such benefit, lordship, because there is a lordship order is also there. In the writ petition lordship, wherein second wife claiming for pensionary benefit lordship, and your lordship has earlier directed to the concerned officer lordship.
That's it.
This is your lordship judgment, lordship.
But I don't think that is a correct premise.
Order to writ petition number 3.
6867/2019. Minor daughter entitled to get pensionary benefit. Even lordship in Assam service pension roll lordship 143 lordship clearly mentioned that lordship. Minor daughter entitled to get pensionary benefit. 143(1). Six, 2019.
This would not apply to you. Here was a case where the wife was a Hindu and the husband was a Mohammedan.
Okay.
And therefore, the issue was gone into as to, you see, whatever it was gone into, because
At that time,
Yes,
lordship,
in
the,
Mohammedan
at
law,
the
there
time
is-
of marriage lordship, in that judgment lordship clearly mentioned that lordship, the marriage was not solemnized as per the Hindu marriage lordship, as per the special marriage act lordship. Therefore, treated her marriage as Hindu lordship. By considering the entire fact lordship, your lordship has directed the authority lordship to compliance and release the
Yeah, but
pensionary benefit in
he
favor of the
he was a
minor
Mohammedan,
lordship.
but he was a Mohammedan.
Even lordship, Assam Service Pension Rules lordship, specifically in 143 lordship clearly mentioned that lordship, the minor son or minor daughter entitled to get pensionary benefit lordship. In column number 3 lordship, even clearly mentioned that
Ah, yes, that's why I was thinking. You see, in paragraph 21, we have said, the claim of the petitioner for pension and other pension benefit is not found sustainable and the requisition stand dismissed. It is only because of the minor child that the sharing was allowed, because the minor child, even if illegal, will have a right.
yes, minor child lordship, we are claiming only for minor child, not the second wife lordship.
Where is that?
But I represented the minor child.
Where is where is the statement? What is the age of the child?
Yes, lordship. Annexer lordship, A lordship. Page number 19, your lord. Annexer A, page number
Yeah,
19.
tell me the age. Is it so difficult?
2008.
2006 lordship he was born and
2006 to
he
age.
died in the year of 2021 lordship.
No, 2016, 2006. Now we are in 24. How many years?
Now lordship, presently she is attaining 17 years for more lordship. At the relevant point of time lordship, she was also minor, having age 15 years lordship. And annexer A1 lordship, she is also minor. She was date of birth was 17th of August 2008. At the relevant point of time when her father was died lordship,
It's
she
the
was
age,
attaining
the age when
13
we
years.
are passing the when we are issuing a notice of motion. We are not concerned with the earlier age when you made a demand. But then you'll have to amend your cost title. Your name has to be removed. You can be a best friend.
Only because lordship, my second wife name has been improved on only because of that lordship. She was represented. Not claiming her pensionary benefit.
That will
to
not
her.
do. When you are claiming something for your child, you will only represent her as a guardian,
Yes,
next
name of the
friend,
child.
not as a petitioner.
I will make appropriate amendment. Lord.
You
Yes, it's
make
my
the
duty.
correction.
Even lordship, the petitioner number 4 lordship, who is the son lordship, he is entitled to get the pensionary death benefit of his father lordship.
No, that's okay.
Yes.
We are not. We are only you're being a petitioner, number 1. Mr. M. Sekhar and counsel for the petitioner submits that the petitioner number 1 is representing the petitioner number 2 and 3 who are minors. In that event, it would be appropriate that the Whereas the petitioner is not claiming any relief for herself, comma, her name be deleted as respondent number 1. And you would and the prospective inspector of number 2, 3, and two, 2 and 3, the amendment says to allow them to be represented by the petitioner number 1 as mother and natural guardian. Next, the learned counsel for the petitioner shall submit an amended cost title to the AOJ, civil rule within bracket pending, bracket section. And accordingly, on receipt of the amended cost title, the central issue shall also be amended. The striking to the name of respondent petitioner number 1 is allowed without altering the seniority of the parties in the petition. Next paragraph. The petitioner's claim entitlement to pension and other pensionary benefits for respondent numbers, petitioner numbers 2, 3, and 4, being the son of the deceased government employee, namely late Govind, Gobinch, Koch, Koch, who had died in harness while working as Havildar within bracket AB, bracket was of under the office of the Commissioner of Police, Kamruk Metro, Guwahati. Issue notice of motion returnable. Yeah, so that's pending amendment of cost title. Issue notice of motion returnable on give the send it after 5 weeks.
Stay order may can be granted. Stay order may can be granted
stay?
if
No.
if sanction order has been passed in favor of the first wife without the knowledge of the.
No, that's
It is
okay.
last.
Somebody is getting money, we are not stopping it.
No, otherwise, Lordship, my minor child will be deprived, Lordship. Yes, because Lordship, entire death benefit has been released in favor of the first wife, Lordship. Although, Lordship, the minor child entitled to get such benefit as per pension rule 143, Lordship. Even Lordship in column number 3, Lordship,
that is
clearly
not her
mentioned
fault.
that, your Lordship.
That is not her fault. Your husband is
Well,
not.
Lordship, she has collected
No,
all
your husband.
document, Lordship, with a promise that, Lordship,
you should-
together will apply before the authority, Lordship. But
Your-
subsequently, Lordship, subsequent instance, she never communicated to me, Lordship.
What is
What
the
is the
requirement?
fault of the?
Where is the requirement? Where is the legal requirement to tell you?
Lordship, death benefit and also
Understand,
pensionary
tell
benefit,
us.
Lordship. What is the
What
fault
is-
of my minor child, Lordship?
That is another thing. You can only curse your husband who is no longer there. He did not make entry in the what you call the service records of you and your minor children.
At least, Lordship, until the communication made out to us, Lordship, till pensionary benefit has been suspended, Lordship. So, Lordship, the law says, Lordship, in column number 3, Lordship, pension awarded under the rule in the section will not be payable to more than one
many-
member
how
of
many-
an officer's family in the same time, Lordship.
How many people are there in the family of the first wife?
Yes, there are the 3 children, Lordship.
Then
All children attaining major, Lordship. In my lead petition, I have already mentioned, Lordship. Only the first wife
I
has
don't
receiving pensionary benefit,
I
Lordship.
don't understand. You are making petitioner number 4 a party, although he is an adult.
Yes,
You say that he is entitled to claim.
yes.
Now, when it comes to the adult children of the first wife, then you say he is not entitled to claim.
First wife always entitled to get pensionary benefit, that is
I'm
lost
asking you a
lordship,
specific
no more
question.
about
Please
argument
don't
about the
divert the
same law.
attention. I'm asking you a specific question. Please respond to the specific question.
Yes,
Correct? History, geography, we are not ready to
Yes.
hear right now. We are asking you a specific question. You say that petitioner number 4 is an adult child of petitioner number 1.
Yes.
You say that he is entitled to pension and other pensionary benefits. Give us one reason why the first wife adult children will not be entitled to.
first wife entitled to get such benefit lordship, and the other benefit also entitled to get the children out of arising out of the first wife lordship. Okay, that is the another part lordship. The pension will be divided in two part lordship. That is the children or the first wife, and the another part is the children out of the second marriage lordship who is in minor lordship.
Yes, correct?
So lordship.
Lordship, minors, definitely they will get lordship, but here what they are claiming, the other communications, they have not mentioned it lordship with the authority concerned lordship.
No, no, not that. For the purpose of stay.
Stay
Um,
lordship, the others will be without hearing the other party because she is the beneficiary lordship, the private respondent.
No other
It-
lordship. If the
Is it extra price? Is out on the runner department was called Mrs. M. Bhattacharya done additional senior government advocate accepts notice on behalf of respondent numbers 1 to
1 to 7 lordship,
7.
8 finance.
Okay. Finance was there. Mr. P. Nayak, done a standing counsel for the finance department accepts notice on behalf of respondent number 8. Next, the petitioner shall take steps within 2 days for service of notice on the respondent number 9 by registered post with AD. The petitioner shall correct the postal receipt number and submit postal track report prior to the next date of listing. Next, till further orders, comma, the Mr. Nayak, this respondent number 8 shall not disturb this 20% of the pensionary benefit to respondent number 1
50% of the pension avenue.
till the next return of the date, as an interim measure, the treasury officer, Kamrup Metropolitan, Guwahati, shall withhold disbursement of 50% of the pensionary benefit in respect of on the death of late Govind Chand Koch from the pensionary benefits currently being disbursed to the respondent number 9, namely Srimati Buddheshwari Koch, wife of late Govind Chandra Koch. Full stop. Next part, it is clarified that this order shall not preclude the respondent number 8 from disbursing 50% of the pensionary benefit to the respondent number 9. Next part, this transfer. Yes, you wanted to say something?
No.
Item 18,
I am obedient.
Here the
Yes.
issue is one of retention of the general pool residential accommodation by officers in the All India Services cadre. These officers, my lord, were serving in the border security force and are posted in the northeast region of the country. In the earlier, my lord, all office memorandums and the rules had allowed them to retain their accommodation held at their last place of
Okay.
posting.
We have issued
This is
notice,
a pending lordship.
we have issued notice in the matter. heard Mr. R. Mazumdar and counsel for the petitioners. Also heard Mrs. R. David and CEC appearing for all the respondents.
Lordship.
All the respondents. Next one. The petitioners claim that as per the policy in force, they are entitled to retain their quarter on their posting in the northeast region.
It will be non-family locations. They say it is non-family location.
In the northeast, in the non-family locations. In terms of office memorandum dated 1/8/2018. Where is your notice?
Well, we have not been given notice, we have not been allowed the extension. And there is a general circular, my lord, which says of 6/10/2022, which lordship should find it page 97, which says that coercive action is to be taken. That has been stated by this honorable court. As a general policy, they are not extending it.
Okay. So however, the petitioners are aggrieved by non-extension of their
Allotment.
retention of the quarter beyond 6 months.
Yeah.
It is also submitted that while OM dated 6/10/2022, the respondent authorities are contemplating coercive action for vacating the family quarters. Next one. As several petitions on the issue is pending for adjudication, issue notice of motion returnable on 5 weeks. Returnable, send it. I do. Returnable on so. Requisite extra copies of the petition be served on the CGC within 2 days. Next paragraph. As an interim measure until the next returnable date, the respondent shall not take any coercive action against the for evicting them from the family quarters which are presently occupied by the petitioners. Next paragraph, the petitioners shall produce a certified copy of the order before whom?
Before the respondent number 2.
Respondent 3.
The 3 is only our controlling officer here. The movement has been made by the Directorate of Estates, respondent number 2.
Okay, before respondent number 2. Next paragraph, list on so.
When restraining them, is on eviction. They were also recovering the penal rent. But so therefore, any coercive action for eviction or recovery of penal rent.
No problem.
The salary goes.
Eviction or recovery of
Penal rent.
Okay.
I'm deeply obliged.
Supply item 51.
Lordship, we have filed affidavit in opposition, Lordship.
And I have, my lord, sent the affidavit in opposition to the petitioner in Silchar. I am expecting a reply by day after tomorrow. Could lordship have it on Friday or Monday, my lord? Not too long a period.
Okay, Monday, let me issue a notice because otherwise it's in motion column. Heard Mr. R. Mazumdar, counsel for the petitioner, and Mrs. R. David and CEC attorney for the respondents. Next paragraph, in view of the issue raised in the petition, you should notice a motion returnable on
Friday, Lordship.
next Monday, Friday.
Lordship, since stay is operating in this case.
Okay. Returnable on 14/6/2024. Next, the CEC has submitted that he already filed an affidavit in opposition. First off, the learned counsel for the petitioner submits that He would also be filing an affidavit in replying the matter. Next. List in the admission column on 14/6/2024.
Subject to convenience would be 18th, my lord, because 14th is a Friday. I'll try to have it filed. 18th, it will be kept on recording. I'm expecting the reply by tomorrow, day after. Wednesday or Thursday, if I get it, filing, it will not come on record. So 18th, if we have it. Otherwise,
Okay,
again on
18.
again on
Okay.
Friday, I'll time to bring it on.
Okay, 18.
Let it be 18th. My interim continues.
Interim order passed in this, I was expected till the next list.
I'm obliged.
Daily list item 19.
Next, sir, during pendency of the contempt petition matter, one earlier secretary has been retired by
Oh,
law.
acha, okay.
So-
Heard Mr. A. Mathur and counsel for the petitioner. Next for this, as well as Ms.
Lordship,
M.
I
Bora,
move to-
learned, standing also for the transport department representing.
Lordship, two already I have accept for newly implemented respondent notice may go, my lord.
Standing counsel. You say counsel for respond numbers 1 and 2.
I pay for respondent 1 year.
Also, you're for 1.
Yes.
Mr. A. Das for counsel for respond number 1 and Ms. M. Bora and it's counsel for respond number 2. Next, Pala. By filing this interlocutory application, the applicant who is the petitioner in the connected contempt petition seeks to impeach
767.
the opposite party number 3 as respondent number 3 in the connected contempt petition. Next, it is submitted that the opposite party number 3 is the present chairman of the state level committee for appointment on compassionate grounds. Next one. No, continue. Also, it is submitted that the on superannuation of the say on superannuation of opposite party number 1, the opposite party number 3 is now the chief secretary to the government of Assam, and he's also the chairman of state level committee for compassionate appointments. And I thought he sought to be implicated in this in the connected contempt petition. Stop. Prayer is allowed. The opposite party number 3 is allowed to be implicated as respondent number 3 in the connected contempt petition. In the contempt petition, in view of the order passed today in the connected contempt petition, in the connected IA Civil 1435 of 2024, the petitioner is permitted to implicate the opposite party number 3 therein. So, according to the counsel of the petitioner shall submit a amended cost title to the who is in charge of the contempt section. The AOJ section. Stop. On receipt of the same, the amended cost title shall be made a part of the contempt petition. Next paragraph. Pending such amendment, issue notice of return on respondent number 3 returnable on the same date. The petitioner shall take steps for service of notice on respondent number 3 by registered postal DD. Counsel for the petitioner shall collect the postal registration number and submit postal track report prior to the next date of this thing. Next paragraph. Pendency of this contempt petition shall not be barred for the compliance of the order of the court.
Lordship already complied with, but we have placed the matter before SLC. Next day, we'll submit. Obliged. Lordship, one thing as I want to submit before this Lord. Petitioner has not served any IA to us, both of us. Without serving us copy, he has filed this interlocutory application.
No, don't do that. You then have to recall the order.
Record is there, madam. Yes.
So once both of them say they have not received, we have to accept their submission. No, it's not there. It's not there.
We have not provided any copy.
Well, it's as on today, my lord, I will.
No.
Please give them.
Oblige.
Item 20.
Just come. Yes.
My petitioner, my lord, matter relates to my lord promotion of the petitioner, my lord, with retroactive effect, my lord. Already I have retired, my lord, on 30/10/2022, my lord. My claim is from the 2009, my lord. I supposed to be promoted in 2009. Subsequently, I have been promoted in 2013. So I am claiming my lord retroactive effect from the date of my lord, whatever respondent number 7 promotion, my lord, who is junior to me, my lord. Let's come to the my lord next one. Initially, I was appointed as a my lord LD assistant, my lord. Page 20.
Yes, you have produced the document.
Lordship, as per last order of the Honorable Court, Lordship asked us to take the instruction regarding under which administrative control BTC was, but BTC given me instruction that they could not trace out that order, Lordship.
No, but then we'll have to deem that he's in the roles of the BDC, because it can't be that
Lordship, he approached,
that the DDO does not have a record of the petitioner.
Lordship, he approached this Honorable Court lately also, Lordship, na? After 5 years.
No. You see, please understand the situation and then tell us. A person is a DDO to the petitioner who is paying him salary regularly. Now, can you say that he is not in service and the DDO is paying him salary? That can't happen. There must be some record, otherwise the treasury will not allow disbursement of salary. If for all other purposes, for so many years, he joined the transfer subject to the BTC happened when? Which year?
My lord, that 2003, my lord, that as per
2003.
BTC agreement, subsequently maybe October, in the month of October 2003, they have
So
transferred.
2003, 11 years.
Lordship,
If there is no document, we have to presume that his service was placed on the day when this BTC was created.
Lordship, that instruction, Assam
So otherwise, you
government
will not be
Assam-
you will not be disbursing salary to the petitioner.
after bifurcation, he is in excise department, we are paying his salary, Lordship.
No,
Before
understand, but-
bifurcation, Lordship, government of Assam can take this instruction.
But how did your DDO get an authority to make payment of salary? Because you see, if in the office of the government, people don't want to work, they will not work.
As per my instruction, Lordship, petitioner was working in the excise branch of the office of the Deputy Commissioner of Udalguri by virtue of transfer. He was drawing his pay and allowances from the excise head of account, that is 2039 state excise, etc. No separate order could be traced by which service of the petitioner was placed under the administrative control of the BTC, Lordship. There is no record to show to whether the service of the petitioner under BTC was in capacity of
No,
the
therefore, you see, therefore, on the day when this head was created, 2039, and you are paying the salary, then he must be deemed to be your employee. That's a presumption you'll have to draw. And if he has not been promoted, you'll have to take a decision, call a DPC and then consider his case for.
Lordship, we give him promotion in proper time, Lordship, as per BTC's gradation list, Lordship.
Pardon me?
As per BTC's gradation list in Excise Department, we rightly promoted him, Lordship. He is claiming that he should be promoted in the year 2009 and he approached this honorable court in the year 2013, Lordship. 14, Lordship.
Yeah, immediately I have representation, submitted representation. After promotion, I am checking for promotion.
But then, where is the gradation list, Mr.
My lord, this is
Sania?
the first gradation list, my lord, which when I was in my lord Dorong district, under Dorong district, before creation of BTC, my lord. I joined in the 1986, my
You
lord.
have to show us some document by virtue of which your
My lord.
earlier service was
My-
protected.
My lord, lordship may come to the, my lord, annexure 2,
Page.
is my lord. Uh, 25, my lord,
Page 25.
my lord. Internal first 4 of the, my lord, gradation list, my lord.
No. This gradation list is okay.
My lord.
The question is, you see, we'll assume that you were an employee under the Deputy Commissioner's establishment
My lord,
on bifurcation and creation of BTC.
my lord.
You were placed under the excise branch.
My lord, in the amalgamated department, DC, my lord, don't excise to other department, dear, it must specific that I am the excise department.
No, can't be. Last time also, when the matter was heard, we were at the same juncture, same question. You see, even in the same department, when the BTC is dealing with the transfer subject,
My lord,
you can't be said to be an employee. You see, it's not a case where you were being granted salary from the establishment of Deputy Commissioner and your service was placed in a different department. That's not the case. Yours is a case where your salary itself was from the BTC.
my lord, that head of the BTC, my lord,
Yes.
excise department.
Now, therefore, you can't say that you were in the service of the establishment of the Deputy Commissioner's office. You were under a transfer subject. Now, when you were transferred to a different establishment, was your pay and other allowances protected, or your service which you have rendered in the state government, whether that was protected?
My lord,
You-
that way I have been not transferred, my lord. While I was, BTC was created, I was working in the Odalpur subdivision, my lord. So it became a, my lord, district after creation of BTC 2003, my lord. My lord. So thereafter, my lord, I have been allowed to discharge my duties in the excise department, my lord. So thereafter, my lord, probably, I'm not sure that, but immediately there is no head of account. Probably it comes, my lord, after 6, 7, my lord, maybe 6 or 7, 2007, my lord. So when my lord, the salary was earlier paid by the government, my lord. When their question was raised, they are working, Gate 3 and Gate 4 is working in the BTC. Whosoever, the salary will go to the BTC head and Deputy Commissioner will be the disbursing authority, my lord. So my salary has been paid by Deputy Commissioner, but as the head of account is for the excise is, my lord, 2039. So from that head, my salary has been deducted, my lord, or paid.
You see, we see it differently. Number one, when your your service is placed under the BTC, and you have a common gradation list for the employees under the BTC.
My lord, no specific order is there that my service has been placed under BTC, my lord. BTC only they have the control who are working in the secretariat, Kokrajhar, my lord. The other staff are milestone transferable. It is not only thing is that, my lord, when they have out transfer from the BTC, some approval is required from the BTC authority. Otherwise, they are the employee of the state government. Like deputation type,
But
my lord.
you're already your head of account.
If I have been appointed after 2003, that is different issue, my lord. There is no specific order that I have been placed under disposal of the
stand of
BTC.
the state.
Lordship, we have filed our affidavit, but regarding that last order, Lordship, we have communicated, but we are still to get the instruction, Lordship.
But Mr. Sarania,
my lord.
you see, once you accept a promotion under the BDC cadre to a next higher post, you can't fall back and say that now I'm still for the purpose of another intermittent promotion. I am the state government employee. You took the benefit of the promotion granted by the BTC, which is under their exclusive domain.
My lord, actually, my promotion was, my lord, actually, I supposed to be get on 2009, my lord. Only thing is that BTC, there, I am drawing the salary under the BTC because their approval is required. What the deputy is doing, my lord, without their approval, they are supposed to.
No, but you have been promoted,
my lord.
In the establishment.
I'm
of
not
BTC.
promoted by BTC, but by the deputy commissioner.
Where is that?
Lordship may come to the, my lord. My promotion order, my lord.
Page 47.
40, my lord, 47, my lord. Yes, my lord.
No, what is the document to show that that your promotion was otherwise due in 2000?
Because my lord, the private respondent 7 is junior to me. He has been promoted in 2009. The entire, my lord, the gradation list of which was, my lord, prepared in the while I was serving the Dorong district, my lord, under Dorong district, under Odalguri subdivision. And thereafter also, my lord, the deputy commissioner Odalguri prepared the draft gradation list. There also my name is above than him.
Where is the promotion? Where is the gradation list of?
First, my lord, I
you-
come
you
to
and-
Dorong, my lord. That is Dorong one, my lord, first.
Is it page 35?
But Dorong was is, my lord, page 25.
25.
My lord. My name is 81, cell number 81.
Your number is 81.
My lord. Who is my lord? The respondent 7 is 85. Eighty-one is the petitioner, my lord. The second gradation list, my lord, is page 35. It is prepared by the Deputy Commissioner of Dalguri, my lord, in respect of the BTC or non-BTC, my lord.
Page 35.
Page 35, my lord. Only here difference in my lord, the which branch they are working, that has been reflected. But
Correct.
here is that branch, which branch they are working, suppose excise, revenue, that has been, or civil supply, that has been reflected here only. Except Sam my lord, he is also still my lord junior in 2010 also my lord, to me my lord. The draft gradation list prepared by Deputy Commissioner.
What is the serial number of?
My name is my lord, petitioner is 19, the private respondent is 20. There is no separate gradation list for BTC.
Then, Madam Tarun, this reparation deserves to be allowed then.
Secondly,
Yes.
Lordship may come to page 44, my lord. There is a my lord Deputy Commissioner, while my lord address to the letter Principal Secretary Bodoland, my lord, some observations will be met, my lord, how he's dealing with the office staff, my lord. Last paragraph, generally, my lord. 44, after the serial number names, the generally, my lord. May I read, my lord. I'm just my lord, national benefit I am claiming, my lord. In another case, Lord, which honorable court has passed an order, my lord, allowing the repetition. Only their difference the excise is not that dispute was not there. But he was also not promoted due to non-applicable by the BTC, my lord. That's one lord boss.
Pass it on.
My lord. You might have certified copy, I could not get, but I have printed out from the only my lord. Modern numbers. Official case status, my lord. High Court.
No, Mr. Rajat, then he becomes entitled to promotion, to be considered for promotion from the date when his junior was promoted. Because if the BTC does not have a document of his service being placed under BTC, he does not become a BTC employee. He will continue to remain a state government employee. For convenience purpose, you are placing him under BTC once he's working under excise department. But you could have called him back to the regular establishment. His service was never placed before the BTC.
My lord.
It's only a convenience that they are doing.
Only
And your in your affidavit, you have admitted that. Your admission is in your affidavit. Your
That the petitioner is in the cadre transferred, lordship.
yes, your that statement you will find in paragraph 8 of your affidavit.
My lord.
You can't escape that admission. Heard. Mr. M. Saranya and counsel for the petitioner also heard. Yes. Eighth article, and government advocate appearing for respondent numbers
1 and 2, Lordship.
1 and 2. As well as Ms. R.B. Borar, and standing counsel for the BTC representing respondent numbers 3 to 6. Next one. Case of the petitioner is that by an order dated 21/5/1986 under memo number DPN dash 8/86 with 4635-39. The Deputy Commissioner, Darang, Mangalwai, had appointed the petitioner as an LDA from typist against government sanction number GAG stop 300/83/49 dated 24/2/1980 in the scale of pay of rupees 470-800 per month plus allowances. Full stop. The petition places reliance on gradation list of grade 3 employees of appointment under the appointment made under the Deputy Commissioner, Darang, Mangalwai. Project that in the said gradation list this in the draft gradation list which was published on 5/1/2024. The name of the petitioner is at serial number 81 and the name of respondent number 5, sorry 7 is at serial number 85. Full stop. By an order bearing memo number UPE-2 oblique 2009 oblique PT-1 oblique 20 dated 14/12/2009. The Deputy Commissioner Darang, Udalguri had promoted the respondent number 7.
Dorong will not come, madam.
Huh?
Only Odalguri, madam.
Only Udalguri. Okay, Udalguri. Udalguri had promoted the respondent number 7
Serial number
under unreserved category as senior assistant within bracket grade 3. Full stop. Next paragraph. The petitioner was placed senior to the respondent number 7 in the gradation list referred above, had submitted a representation against the his, for considering his promotion to the next higher rank of senior assistant within bracket UDA from junior assistant, which was forwarded by the superintendent of excise Udalguri to the commissioner, Lower Assam division within bracket respond number 1. Full stop. Subsequent representations of the petitioner were also forwarded to the respond number 1 for consideration. Full stop. Next paragraph. Now, what is this? This page 35 is what document?
Page 35 in the minor, the gradation list, minor, the gradation list prepared by the deputy commissioner.
Okay. The learned counsel for the petitioner has referred to the draft gradation list published by the Deputy Commissioner Udalguri on 31/8/2010. Project that in the said gradation list, the name of the petitioner appears at serial number 19, whereas the name of the respondent number 7 is placed as at serial number 20. Accordingly, it is presumed that even when the draft gradation list dated 31/8/2010 was published, the respondent number 7 was junior to the petitioner. Thereafter, the petitioner was promoted by an order dated 8/7/2013 to the newly created post of UDA in the excise branch of Udalguri district, and his salary was ordered to be drawn from the head of account 2039-excise. The learned counsel for the petitioner has submitted that the service of the petitioner was never formally placed under the Bodoland Territorial Council, and therefore it is only for the administrative convenience that while serving in the amalgamated establishment of the Deputy Commissioner Udalguri, he was placed under the excise department, which is a transfer subject, and such interdepartmental transfer in the office of the Deputy Commissioner is a regular feature. To support the said contention, the petitioner is relying on copy of a letter dated letter number UPE-17/2005-06 dated
23rd October. 23rd October 2013.
Which page?
Page 44.
23/10/2013. Accordingly, it is submitted that the promotion of the petitioner should be made with effect from, what is the date of
the private my lot 14/12/2009.
The date on which the respondent number 7 was who was his junior was promoted to the next higher post. of senior assistant within bracket grade 3.
I apologize, Lordship. This communication I have received just now.
The other person, respondent number 7, is also retired by now.
Retirement, retired.
You can't take back now. The effect of promotion, can you take it back? You can take it back. We'll take a break and come back. Opposing the prayer made in the writ petition, the learned government advocate as well as the learned standing counsel for the BTC have submitted that the service of the petitioner was placed under the BTC as excise department is a transferred subject. Stop. Accordingly, it is submitted that the petitioner was drawing salary from the head of account 2039 state excise, which is a transferred subject. Stop. According to it is also submitted that as per the gradation list of the employees under the administrative control of the BTC, the petitioner was promoted in his due turn by order dated 8/7/2013. Accordingly, it is submitted that the petitioner is not entitled to be considered for promotion from the anterior date of 14/12/2009, on the day the respondent number 7 was promoted. That's right. Consider the submissions made on the bar and peruse the materials on record. Full stop. It is not in dispute that the petitioner was appointed by the Deputy Commissioner Darak Mangaldev, as it was then, by an order dated 21/5/1986. Stop. The fact that the petitioner was serving under the amalgamated establishment of the Deputy Commissioner is evident not only from the draft gradation list published on the draft circulated on 5/1/2004, as well as the draft gradation list dated 31/8/2010. Stop. It was also not in dispute that the that in both the gradation lists, the petitioner was placed above the respondent number 7. Full stop. Although the respondent number 5 has filed an affidavit in opposition on 7/11/2023. And is taken that the petitioner was promoted to the post of UDA being a candidate under the excise department of BTC. But the respondent of 5 has not produced any common gradation list of BTC employees where the petitioner was absorbed. Before that, the petitioner was absorbed as a regular staff under the BTC. Full stop. In the present district of Udalguri, the said district is placed under the administrative control. The areas in this district is under the Bodoland Territorial Council. It's several departments being placed under the administrative control of the Bodoland Territorial Council. Full stop. Accordingly, it appears that as the petitioner is serving in the excise branch of the establishment of the the present district commissioner of Udalguri, as his service is placed in the excise branch, his salary is paid through head of account 2039 excise. There's no document on record to show that no document to show as stated above, that the service of the petitioner was placed under was absorbed under the BTC. Full stop. As per the said view of the court is also supported by the draft gradation list, which was circulated on 5/1/2004, as well as the other draft gradation list circulated on 31/8/2010. Because both the said draft gradation list appears to be a common draft gradation list in the amalgamated establishment of the Deputy Commissioner of Udalguri, within bracket, now District Commissioner of Udalguri. Full Had the petitioner being absorbed under the BTC, his name would not have appeared in the draft gradation list of the amalgamated establishment of the Deputy Commissioner, Udalguri. Full stop. It also appears that as the petitioner continued to be an employee under the amalgamated establishment of the Deputy Commissioner, his appointment orders were issued by the Deputy Commissioner, which is otherwise permissible under the what is the act? District Ministerial Staff.
My lord,
What is the name?
Please, service rule, my lord.
What is the name?
Assam Ministerial District Establishment Service Rules,
Slow.
1967.
You'll have to
Assam Ministerial District Establishment Service Rules, 1967.
1967. So therefore, if from the said establishment, the petitioner was placed under the administrative control of the BTC by absorption as a BTC employee, there ought to have been an order for placing these services under the permanent control of the BTC. Full stop. There is no such order of absorption of the service of the petitioner under the BTC. Full stop. Therefore, the only presumption that can be drawn by the court is that the petitioner continued to be an employee of the amalgamated establishment of the Deputy Commissioner Udalguri, and as he was placed under the excise department, which is under the administrative control of the BTC, his salary was drawn from the head of account 2039 dash state excise, which cannot be treated as if the service of the petitioner was absorbed under the BTC. Next part. The projection, next para, the projection by the learned government advocates as well as the learned standing counsel for the BTC, that the petitioner is an employee of the excise department, which is a BTC transfer subject, is not sufficient for the court to draw a presumption that the petitioner was absorbed in the absorbed under the BTC, for the simple reason that if the petitioner was a subject of subject dash not subject employee of the BTC, then the Deputy Commissioner Udalguri would have no authority to promote the petitioner by order dated 8/7/2013 to the post of UDA, which was newly created in the excise branch of Udalguri. Full stop. The order of promotion by the Deputy Commissioner is indicative of the fact that the petitioner was an employee under the amalgamated establishment of the Deputy Commissioner, Udalguri. Next paragraph. Not similar, similarly, the same para, similarly. This BTC was created in 2003.
2003, my lord. 31st May notified, thereafter, my lord, from October it's working.
Okay.
2003.
The learned counsel for the petitioner has submitted at the bar that the notification of creation of BTC was issued in
31st May 2003, my lord.
31/5/2003, and that the establishments under the transferred subjects started functioning in the month of October 2003.
30/10/2003, my lord.
30/10/2003. Full stop. The respondent number 7, whose name appears in the common gradation list, which includes the name of the petitioner, was promoted by the Deputy Commissioner of Udalguri by order dated 14/12/2009. So therefore, there is no reason to exclude the petitioner from considering his promotion when his name is placed senior to that of the respondent number 7. Full stop. As on 14/12/2009, as per the case projected by the petitioner, his position in the draft gradation list is at serial number 81, whereas the name of respondent number 7 is placed at serial number 85. Next one. In view of the finding of the court that the petitioner was a employee of the amalgamated establishment of the Deputy Commissioner of Udalguri, within bracket now District Commissioner of Udalguri, post, comma, the District Commissioner Udalguri would be the appropriate authority to revisit the entitlement of the petitioner for promotion on and from 14/12/2009, on the date on which respondent number 7 was promoted. Next paragraph. Before this, before this paragraph, it may also be mentioned that in paragraph 15 of the writ petition, the petitioner has taken a specific stand to the effect that Generally, the employees of amalgamated establishment of the Deputy Commissioner, Udalguri, are transferred frequently from one branch to another for the work under the said establishment, comma, the employees get their salary under head of account 2029-LR when they work in the administration, comma, election, comma, planning branch, etc. And when they are rendering service under the various revenue circles, they draw their salary from the head of account 2053. Full stop. The said statement of the petitioner has been admitted in paragraph 8 of the affidavit in opposition filed by respondent number 2. However, the respondent number 5 in his affidavit has made no comment. His statement made in paragraph 15 of the red petition. First of therefore, comma, we are going to non-less specific denial of the statement made in paragraph 15 of the red petition. By the doctrine of non-traverse, the statement, the said statement is deemed to be admitted by the respondent of 5. First of, except for respondent numbers 2 and 5, no other respondents have filed their affidavit in opposition. First of, therefore, the said stand of the petition is also deemed to be duly admitted by all the respondents on the failure to deny statement made in paragraph 15 of the red petition. Accordingly, this red petition deserves to be and is accordingly allowed. The court is inclined to hold that as the name of the petitioner is placed before the name of the respondent number 7 in the draft edition list dated 5/1/2004 and 31/8/2010. The petition is held to be entitled to be considered for promotion from the on and from 14/12/2009, on the date on which the respondent number 7 was promoted by an order passed by the Deputy Commissioner of Udalguri. Next, as the petitioner is already superannuated on
30/10/2022.
30/10/2020.
30/10/2022.
22. The petitioner is entitled to financial benefits on and from 14/12/2009. To the extent that has accrued upon such deemed promotion on and from 14/12/2009, Next para. The respondent, the district commissioner of Udalguri the authority which was erstwhile designated as the deputy commissioner of Udalguri shall pass consequential orders within an outer period of pass consequential orders for granting of notional and financial notional and financial benefit to the petitioner, as well as to pass constitutional order to give effect to the promotion to the petitioner on and from 14/12/2009, or the date on which the respondent was 97 was promoted. So it shall all be done within a outer period of how much? How much time?
6 months, Lordship.
4 months?
Lordship.
4 months from the date of receipt of certified copy of the order.
Lordship.
On the date when certified copy of the order is furnished to the district commissioner, Udalguri.
My lord.
Lordship, my once there, he has approached this honorable court after 5 years, Lordship, that my submission may be recorded. Lordship. His promotion ought to be given in 2009.
He is
14 I approached.
you
13
show us
promoted.
any law which prohibits him from coming.
No, but
No, it's okay. You make your submission. That's okay.
maybe recorded.
No. I'll record only when you satisfy us. Where is the law to say that after 5 years you can't come for promotion? Show us any
He
law.
himself said, Lordship, he himself said he ought to get.
No,
the
no. We
promotion
give you
in-
time. I'll sign this tomorrow morning. Till today night, you have time to study and come us and tell us that there is a authority on the point when after 5 years somebody comes for promotion, he is not entitled to. You show us, tomorrow we will not sign. You give you time till tomorrow morning, till 10:30. Before 10:30, I sit, you tell it to the court master. I will not sign. No, each and everything you can't be recorded. You see, you are a standing counsel. Whatever you say, we are accepting it to be correct. But you show us any law which says that after 5 years he can't come.
My lord.
We'll dismiss our petition tomorrow if they can show any law.
No, Lordship, I am not saying need to dismiss.
No. You see, you want us to record. Because you see, if I record this, I'll also have to record my displeasure on such submission being made. But then I'll have to record my displeasure. You take your call, I'll do both.
Lordship, I'll leave
Whatever you want. No. Please,
Leave it
you
to
see,
us.
don't go out of at least this courtroom
it to us.
with a feeling that I have not heard you.
No.
I'm giving you 2 options. First option is that I don't record it. Therefore, I don't have to say something in the order. But if you insist that it has to be recorded, then what I record is at my pleasure.
Lordship,
Correct? I'm not supposed to ask you what I'm writing.
Lordship,
I just love interacting and then smile all throughout. Therefore, I'm doing that. But what I will write is my pleasure. Doctrine of pleasure is here. Correct?
Lordship, this-
No.
this-
Once he is entitled to, he is fighting for it for last 2014. Now we are 10 years down the line. After 10 years, I am not holding him bad for, you see, there are judgments of this court by a division bench as well as I have authored judgments where I've said that if you take a preliminary
Objection.
objection in a writ petition on the ground of limitation, it should be taken as a preliminary issue. When we hear it after 10 years of filing, that is lost.
My lord. I'll oblige. Any my lord, if my learned friend anything brought against me, I'll get an opportunity. My
No,
lord.
Lord, you are let it.
I'll oblige. my
Absolute
lord.
lordship. Deeply obliged.
Yes, item 21.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. J.M. Lordship. There's a case in Your Lordship that there is an office memorandum granting disability pension, disability allowances to the state government employee, Your Lordship. Your Lordship, earlier there was an office memorandum of 24/3/2010 whereby rupees 500 per month was granted. Subsequently, Your Lordship, it has been enhanced, annexed to page 16 by
Yes.
19/4/2007.
My lord, this matter, my lord, listed after so long time, my lord. Lordship may grant 7 days time, my lord. I'll take up to the instruction, my lord.
No, there is no instruction at all.
Yes, my lord.
He says that the file is missing.
Yes,
Yeah.
as per the
He's
petitioner, my
also
lord.
saying that there's a order of
They have
sanction.
processed, but they have
Yes.
lost the file. I have
As
lost.
per the petitioner's case, my lord, I've gone through, my lord. The case is that, my lord, although from the district that was forwarded from the commissioner office, that was missing at that time. When now at present, my lord, what happened, my lord, I have to take.
Next Monday.
Next Monday.
Okay. That is the counsel for the petitioner. Mr. S. Datar has standing counsel for the PNRD department. Praise for his granted time to obtain instructions. List on. One next Monday is Monday is closed. Make it
Monday is closed, 19.
19.
19.
And I can give assurance, my lord, if he is eligible, my lord, then he will get. My lord.
Okay.
Yes.
All right. I'm also grateful to my friends.
Oblige me.
22.
That's it. If I look through it, I can. Item 20. Item 20. Huh? Yes, 22.
My lord, the writ petition has been filed for direction to the authorities to finalize and pay regular pension, leave encashment, and death cum retirement gratuity, as well as other retirement
Where is the document of your regular employment?
We retired from service. The clog is, they say that pendency of some criminal proceeding against me is the bar.
Okay.
They
Where is that?
They have taken a stand. I'll place the matter, my lord. They've taken a stand in their affidavit, which is more important. And they say that regular pension and DCRG in respect of the petitioner could not be processed. I emphasize, due to pendency of vigilance case number so and so against the petitioner. The department is awaiting result of the above judicial proceeding.
Who's the respondents? You are there. Any order was passed under section 21 rule 21 to.
Rule 21 on apply lordship because he was charge-sheeted when he was in service.
I would place
Lordship,
my case.
the date of occurrence took place in 1999.
Yes.
The FIR
that
was
is not my
filed on
case.
2002 lordship.
That is not even my case.
Then?
She's building up an argument, with all respect, which is not my case. That's
Okay.
not my case.
What is your case then?
My case is, if I go to pension fund.
And the quashing petition is pending before the apex court lordship.
But that is again not
As
my
per
case.
their-
But they are not letting me place my case.
No, I am not in it. Not.
I understand, my lord. I especially understand. We say, Rule 21 of the Assam Services Pension Rules is in 3 parts.
Yes.
One is, when do we understand a departmental proceeding or a judicial proceeding, in that case a civil or criminal proceeding, to start or to have initiated? I am not on that part. The other is the 4 years time period, retirement part. I am not also on that part. That's their objection. I'm not on that part. Given. I am on whether during pendency of any proceeding, number one, is there any jurisdiction vested on the commissioner and secretary, not even on the governor, honorable governor, to withhold my pension? I read Rule 21. Just to, I can give my book. They say Rule 21 would not apply. It has to apply. That's the only source by which you can stop my pension. Otherwise, it's on the face of it writ large. Lordship is there.
Yes.
May I read? The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to a government, if in a departmental or judicial proceeding, the pensioner is found guilty of gross misconduct or negligence during the period of service, including service rendered upon re-employment after retirement. My lordships, it has to conclude.
Is it?
I have to be found guilty. Prior to that, Rule 21 does not germinate. The jurisdiction under Rule 21 only starts when I'm found guilty.
Not during dependency.
Not during dependency. That's my case, number one. Now comes the second limb of my argument. Admitted positions of facts are: cognizance was taken on 31/3/2012. Cognizance was taken on 31/3/2012 in context when Ejahar lodged on 2/9/2002. I'll give the dates, Miller. I'll give the date. I'm not a facts. Dates I'll give, Miller. The alleged incident of 99, Ejahar of 2/9/2002, the cognizance in 2012, and I retired in 2018. So this argument of 4 years and all would not hold water if I goes that way.
Charge.
Alleged incident 99.
Yes.
Ejahar 2/9/2002. Cognizance 31/3/2012. That's at page 42.
31.
31/3/2012.
Yes.
And I retired on 28/2/2018. 28th of February 2018.
Yes.
Now I'd filed a criminal petition in 2012. There was a stay order 2/4/2012. Ultimately, it was dismissed on the 7th of June 2013. As against that, I moved the SLP. Page 46 would be relevant. Supreme Court's order on that. Page 46. Lordship is there. May I read? A substantial question of law arises in these special leave petitions as to whether the trial court can proceed with the prosecution of government servants even when government refuses sanction for prosecution under Section 197 CRPC or Section 19 of Prevention of Corruption Act 1988. Issue notice. In the meanwhile, there shall be stay of further proceedings in the Court of Special Judge Guwahati, Assam, in special case number 19 of 12, arising out of Vigilance PS case number 2 of 2004, and special case number so-and-so arising out of so-and-so. So the proceedings are stayed on and from 25th of June 2013.
What is the fate of this SLP?
Continuing. Not over.
SLP criminal
5080.
5080. Okay. It would. SLP criminal 5080 2013. Last date of listing here is 25/6/2013. Current position, huh?
Lordship.
Yes.
My lord, at this position, my arguments would be, my submissions would be threefold. Number one, admitted position is, it has not concluded, I have not been found guilty. So therefore, 21 does not apply, number one. Number two, if I have pointed out that there is stay by the apex court, what would be the legal impact of a stay? Stay of proceeding. If there is stay by higher forum, what does it mean in legal parlance? Otherwise, on that note, may I present this judgment of the apex court? Whether I can say that the proceeding is pending. It has not concluded. The second, I have to address whether it's pending. Naturally.
Naturally, it will be pending.
I'll address on that. Pendency, I say they have no jurisdiction. Still. Now, this, my lord, the first, if I may read, the short and straight question which arises for consideration is, quote, whether a dispute is said to be pending before an industrial tribunal for the purpose of revision to section 33(2)(b) of the ID Act 47 during the period when the operation of the order of reference of the dispute itself remains stayed. So whether during stay, we can say that the proceeding is pending. I invite my lord's attention to internal page 7 at the foot. Lordship is there. May I read the last paragraph? The effect of grant of stay of operation of the order of industrial reference was that the industrial tribunal could not take up the reference for adjudication. Consequently, no action based on such reference could be taken by the tribunal, including grant or refusal of approval to the disciplinary action under section 33(2) of the Act. The employer could not have, therefore, approached the tribunal for seeking approval to its disciplinary action so long as the order of reference remained stayed by the order of the High Court. The industrial reference stood revived only when the writ petition against the industrial reference was finally disposed of by the High Court on 12/4/1999. The industrial reference would be said to be pending only from 12/4/1999, my lordships. In that case, the pending would come when the Honorable Apex Court proceedings are concluded or the stay is vacated. On and from 25/6/2013, Miller, the case against me cannot be said to be pending also because of grant of stay by the Honorable Apex Court. That's how I present my case. Even if it's pending, there is no jurisdiction, but I would address on this issue in this passage.
But it's something which is otherwise unacceptable.
Sanction.
The reason being, you see, let us say in the last year, 2023, 100 writ petitions were filed before this court. Correct? Out of 100 writ petitions filed, let us say 5 writ petitions have been stayed by the Supreme Court. Now, in the pendency, what will you do?
Eclipsed. They're eclipsed.
No.
They're not aborted. They're
No,
eclipsed.
in my statement, what will I show? Writ petitions filed is how much?
That's on the executive part. We're on the legal part of it. Executive part, lordship may show. The statement may be made by the concerned clerk that these are pending. In his understanding, that'd be fine. But when I address your lordship as an officer of the court, how did the legal part of it? That's how the Honorable Apex Court goes about it. It's not pending. It's eclipsed for the moment. Of course, that can amount to a pendency of a case, but not pending to say that the judicial proceedings are pending. I'm on that part of the matter. That would not come to his imprisonment, my lord. But regardless of it, whether it's pending or not, I say that there was no jurisdiction to invoke this. More so, if they can show that the Honorable Governor had sanctioned withhold, I still may consider that he was wrongly instructed or aided maybe. But if the Commissioner and Secretary exercise the power, he has no jurisdiction at all. Straightway, he has no jurisdiction, my lord. And the affidavit is sworn by The response number two, I believe, response number two is the Commissioner and Secretary Miller. Now, here is an affidavit sworn by an officer who holds the rank of Commissioner and Secretary, Government of Assam, Department of Pension and Public Grievances, this board. He says, that regular pension and DCRG in respect of rate petitioner could not be processed due to pendency of so and so as a petitioner. It does not say that there was sanction of the Honorable Governor to say that do not process or withhold. Apparently, bad in law. Let them address on that issue at all. Only that issue. Nothing more is required. Provisional pension, yes, I've received. I'm entitled to my full pension under the law. Yes.
Page 70 of my affidavit, Lordship, there is a OM of the personal department, Lordship. Page 70, Lordship.
Yes.
The last Lordship, the second paragraph, Lordship, it is clarified that the retired government employee against whom any department or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and the issue of final orders thereon. So the judicial proceeding has not concluded, Lordship. So, Lordship, we are not being able to give the final pension. And moreover, Lordship, the section 21 of the pension rules won't apply because, Lordship, when the charge sheet was issued, Lordship, he was in service. The date of occurrence of the event was on 1999. FIR was filed on 2002. The charge sheet was issued on 31. Cognizance was taken on 31/3/2012, Lordship, and he retired on 28/2/2018.
How far would this page 70 will help you?
No.
Lordship, we cannot come. Lordship, the judicial proceeding is stayed by the apex court, Lordship. That is the problem. The whole proceeding has been, Lordship.
How far this will help you? You see,
Lordship.
no amount of OM can override the pension rules.
Lordship.
Correct. Pension rules are under 309. Is it?
Yes.
So therefore, OM not being issued under Article 309 will not have a overriding effect of the pension
But
rules.
Lordship is not acquitted
No,
in the
no,
judicial proceeding.
I'm not yet over.
Yes, yes.
I'm not so straightforward. That's not yet. It doesn't override the pension manual, pension rules. Therefore, this can only permit you to withhold DCRG, death come retirement gratuity, and nothing more. You look at your OM again, it says DCRG, doesn't prohibit pension.
Till the Lordship may I read, Lordship? In pursuance of the approval of the Cabinet held on 7/6/2012, the Governor of Assam is pleased to order that henceforth all administrative department, heads of department and heads of offices of the district shall issue provisional pension, provisional family pension and DCRG to all retired government employees of the state government as admissible soon after their retirement till the final PPO is issued by the Accountant General, Assam, and the Director of Pension, Assam, as the case may be under the provision of Rule 22(1) of the Assam Services Pension Rules 1969. it is clarified that the retired government employee against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and the issue of final orders thereon. Lordship, the
Pension
final
is-
PPO is
pension is-
issued by the accountant general, Lordship, with a
Okay, but
limited
the
knowledge.
pension is excluded.
Lordship,
Your OM, in your OM, pension is excluded.
Lordship, the final PPO the
That will
final
be wrong. It
pension
has to be
payment order
disbursed.
has to be given
It
to
has
the
to be
accountant
disbursed.
general. And for that, the judicial proceeding has to be completed,
There's
Lordship.
a judgment of this court, Madan Mohan. 2006.
Six two GLR 736. 2006 two GLR 736.
You have that?
I don't have that.
2006,
Two GLR 736.
7.
36. Lordship may for his, so that two.
It's crystal clear that the power to withhold the pension on the ground that a departmental proceeding or a judicial proceeding may be initiated in the future. No, it's not a future.
So that would not come in because here is a case where the commissioner and secretary has wrongly interpreted their OM. And taken it to be an invocation of 21.
This case will not come.
This is anticipated in the future. So far as the other part is concerned, the rule, page 70, which the OM is being attention withdrawn, this does not even give the jurisdiction of the commissioner and secretary to withhold the pension. It reserves the right to the governor, and that too when it's concluded and found guilty. That's all I have to.
Continue to.
I might take a little bit of time. There will be another.
Your
matter open up.
your SLP is still SLP is still pending.
Pending.
31/1/2020. But that was the last date.
On that count, I rely on this to say that there is no continuance also.
He's not acquitted in the judicial proceeding.
Not even convicted.
So
Let's see it too.
Lordship.
Or 25th, whichever is convenient.
Bisari. Okay. Help Mr. Gogoi.
I've informed them. I've
Okay,
informed
okay.
deposit for me.
Okay. Who says a representative on the claim made by Mr. A.K. Bhattacharya and his senior counsel, assisted by Mr. D.K. Bhattacharya, counsel for the petitioner, list on 206/2024.
503. एक मैंने पोल दिले को मेंशन नो Last people actually, not also. Last kill, my consider. Where was I last?
Before I see. On that, their jurisdiction under the page 70 memorandum, which says only the CRG, good or bad.
As per this office memorandum, Lordship, the judicial proceeding is not completed yet, Lordship. Moreover, Lordship, he is not acquitted in the judicial proceedings. At his own parlance, Lordship, the judicial proceedings stayed by the Honorable Apex Court, Lordship.
I've not been convicted, my lord.
Neither he is acquitted, Lordship. As per Rule 21, Lordship, of the Assam Service Pension Rules 1969, and the OM of the Personal Department dated 24th June 2012, Lordship, we are withholding his final pension, Lordship. He has misappropriated crores of rupees, Lordship.
No, that's an allegation. No, what happens is, regardless of whatever is the outcome,
But you see, you could have simplified things when you know about the Supreme Court proceedings.
Lordship.
You know the question raised. Yet the government did not use wisdom, did not give sanction.
The matter in the Supreme Court was regarding the prosecution.
No, that's okay.
Lordship.
Once you say that there was a misappropriation of crores of rupees, there must be some interest for some people not to give sanction. So we are, at times the government is following the communist system of governance. You understand by that?
Lordship, once the judicial proceeding is not completed, Lordship, by chance, like, Lordship, if he is convicted in the proceeding, Lordship, it is difficult to recover.
no, there will be
Lordship,
no
he is
question of
getting
recovery.
provisional pension,
The day I'm
Lordship,
convicted,
51,000.
No,
He is
from
getting
that
provisional
onwards, it
pension,
will be stopped.
Lordship.
Those are different things.
Lordship.
Let us say in a criminal case, he's convicted. So what is the sentence which is going to be passed?
Recovery.
He'll be incarcerated for some years and he'll be imposed a fine. That's all. Can you tell us any case where the fine imposed by a criminal court on a person convicted under Prevention of Corruption Act? What was the maximum fine which was levied? Has to be proportionate to the punishment given. Disproportionate fine cannot be imposed by a court. If in a criminal court, you can ask for recovery, that is something I don't know. Recovery of the amount misappropriated, if that can be a punishment given under Corruption Act, you don't know.
If Lordship comes to Rule 21, Lordship.
I'm there at Rule 21, I am holding that.
Lordship.
Page 16, I am holding that.
Lordship, the governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government, if in a departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall, after the final retirement of the officer, be deemed to be a proceeding under this rule and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service.
What is the condition precedent?
So, Lordship, another order of the governor is not required, Lordship. Lordship, the rule shall be continued and concluded by the authority by which it was commenced in
What
the
is the
same manner
condition
as if the
precedent of 21?
departmental proceeding.
No, it is only the governor of Assam. That is the condition precedent.
But as it was started, Lordship, it can be continued as it was initiated.
No, nobody says it can't be continued.
Yes, Lordship.
Criminal proceeding can continue, but here we are referring to pension.
Pension,
Where can the pension be stopped?
the governor of Assam reserves to himself provisional pension he is getting. The final pension, Lordship,
If
the
you-
governor has the right to reserve the pension as far as if as it is started, Lordship. Such, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall, after the final retirement of the officer, be deemed to be a proceeding under this rule and shall be continued and concluded by the authority.
But did the
By the authority, Lordship,
but
by
did the
which it
governor
was
reserve?
commenced.
Did the governor reserve?
Lordship, but by the authority by which it was
They are
commenced,
referring to a
Lordship.
departmental proceeding.
By the authority,
The
Lordship.
proviso
The commissioner
relates to
secretary,
that.
Lordship. As
Please
it was
read again.
commenced earlier, Lordship.
Please read again.
Lordship, such departmental proceeding, if instituted while the officer was in service, whether
So
before
this is, we are not speaking about departmental
Yes.
proceeding.
Huh.
Yeah,
Judicial proceeding is C, Lordship. A, then explanation, Lordship. B, 1, 2, 3, and judicial proceeding is C, Lordship. Page 11. No such judicial proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution.
Does not apply to me.
It doesn't apply because the judicial
Absolutely.
proceeding was when he was in
No, doesn't
service.
apply to me. I agree to that.
So
But the judicial proceeding, Lordship, it was commenced by the authority, so it, Lordship, the question of
Judicial proceeding is never initiated by the authority.
Third. Mr. S. Banik, counsel for the petitioner. As well as Ms.
Arborologist.
Bora Leonard, standing counsel for the Agriculture Department representing respondent numbers
1 and 3, Lordship.
1 and 3. As well as Ms. But it's
2 and 5, Lordship.
But it's as you learned, government advocate appearing for respondent number 2 and 5, and Mr. D. Bhattacharya, and then standing counsel for respondent number 4. Next one. Mr. Bhattacharya, you have anything to say?
The documents come from the department, what you have, the state still remains the same.
Ours also stand is same, Lordship, because we are only the bench of dispersing authority, Lordship. Respond number 2, Lordship. So until and unless this is referred to us, Lordship, no actions can be taken.
On the point of law, with regard to that, section 21, anything you have to say? No. On the issue of law,
Sure, Lordship, he has not faced the trial, Lordship. This is the there. Pendency of a case cannot be taken as that he is innocent or he has not been convicted. Nothing can be concluded, Lordship. And he has been granted with the, so far as I have come to know, Lordship, the provisional pension is there and other retirement benefits has already been provided to him, Lordship. Only the TCRG, which is as per the rule, Lordship, this can be withheld, and pension, Lordship, regular pension because of pending criminal case. And he also has not pursued the case, Lordship, to come to an end. From 2013, more than 10 years, the matter is pending before the Honorable Supreme Court, Lordship. So he also has not taken any this is, Lordship, pursued the matter that to
the government may take legal advice. They are good consultants. And I don't think my response is necessary. The case of the petitioner, in brief, is that while holding the post of Joint Director of Agriculture, NZ Roman 2, Dhemaji, he had superannuated from service on 28 to 2018. The Background. Facts is to reflect that that the purportedly it's called veterinary scam. That the same thing. A scam.
It's called greenhouse.
Huh?
It's a greenhouse scam.
Greenhouse scam.
I'll give you exact words.
A scam.
No, it's not greenhouse scam. It's greenhouse come rain shelter scheme. It relates to greenhouse come rain
scam,
shelter scheme.
which is popularly known as scam for greenhouse
Come rain shelter scheme.
come rain shelter scheme. you were calling it, happened in the year 1999. First off, a formal FIR about the said case was lodged in the year 2002. You have the date? No, 2002. 2002. First one. The Court of Special Judge Assam took cognizance of the offence by an order dated 31/3/2012. First one. The petition approached, he came to this court first.
Lordship.
Approached this court for questioning of the FIR as well as the proceedings, criminal proceedings. First one. How the
There was a stay initiated.
Huh?
Stay order dated 2/4/2012.
No, that may not necessarily
Dismissed.
because this court by order dated 7/6/2013 had dismissed criminal petition number 234 of 2012.
So this will be 176 of 12. So far as this petition is concerned.
176. Okay. Oh, okay, 176 of 2012. Full stop. The said order was assailed by the petitioner before the Supreme Court of India by filing SLP with the criminal CRN aggregate number. So what is the number of your case?
Forget that, madam. Seven, 6, 13 inch here. Lordship is it's 242 of 12.
Hmm? So which page you showed?
46.
46.
46. 242.
The criminal petition number is 242 of 2012. Supreme Court. Criminal numbers 5080 of 2013. No, not this.
You know, there are few minutes. Page 9, Lordship indicates.
Page
9. The entire proceedings are stayed.
No. This
I understand.
number.
Refer to the number, madam. I'll get the correct number. For that.
We have to give a correct number.
Lordship. Page 9, that paragraph D.
Page
9, paragraph D. Paragraph D. So one such order was given. With a stay of the entire thing was stayed. The
No,
proceedings.
I understand, but what is
I
the,
understand.
this is your case?
I'll get that number, brother. I'll get the number. Taken marshal, say, taken marshal. Different, taken marshal. 5083, 5080, 5080, 5080. Especially if taken, 5080, birthday. It has to be with someone. It's an others and another.
Different lordship.
No.
Page 46 and the page 9 lordship.
What I'm trying to indicate is check
No.
page 9, Mujahid Ali and another, Noor Islam and others. So I'll just check up that another's partner.
He's trying to project that you see there are 1, 2, 3, 4, 5.
Yes, 5080 on the top, then 5081 to 5082 and 5083.
So 5 SLPs were there.
Yes, with
In the 5,
Yes, Lordship.
in the 5 SLP, the proceedings of special case number 19 was stayed.
Stayed.
So it's not necessary that it would be, there would be stay in his case, in his SLP also. Once the trial court is proceeding is stayed, it will cover all the accused persons unless excluded. Or the Supreme Court would have said that stayed only in respect of the petitioner or appellant. That's not the point. By referring to the order dated 25/6/2013, passed by the Supreme Court of India in SLP criminal numbers 5080 of 2013. It is stated by the learned counsel for the petitioner that the proceedings of special case number 19 of 2012, which was pending before the Court of Special Judge Guwahati, Assam, Guwahati, arising out of evidence PS case number 2 of 2004 and special case number 24 of 2012, arising out of vigilance PS case number 1 of 2004, were both stayed. Full stop. In the meanwhile, as stated above, the petitioner has surrendered from service on 28/12/2018. Next para. The Director of Agriculture by letter dated 25/7/2018 forwarded the pension papers of the petitioner to the Secretary to the Government of Assam, Agriculture Department. And accordingly, the said authority has submitted a proposal for sanction of GIS saving fund of the petitioner to the government by letter dated 30/11/2018. This money has been paid to you? No. GIS?
I have to check up. Should have been paid. I'll check it.
In the meanwhile, provisional pension was sanctioned to the petitioner. The order dated 18/4/2019. Pending final pension, the finalization of final pension by the Accountant General in the E&E Directors Assam. Next one.
In Supreme Court is 5083, my number. I've checked.
Your number is 5083.
Serial number 15 is Hitendra Kumar Datta.
SLP 5083.
Oh, 13.
2015. Next one. Yes, there is one counsel for the petitioner, referring to the judgment and order dated 25/2014, asked in WPC 4999 of 2013, dash Nurul Islam, NURUL Islam versus the state of Assam and others. Submitted that under similar circumstances, by interpreting the provision of Rule 21 of the Assam Services within bracket pension, bracket close rules for 1964. This court had held to the effect that when a criminal proceeding pending against the petitioner is found to be barred by Rule 21 within bracket C of the Assam Services within bracket pension, bracket close rules, on the ground that it was instituted in respect of an event which had taken place more than 10 years before his retirement. Rule 22 cannot be taken recourse of by the respondent authorities to withhold his final pension. So accordingly, this court had interfered with the denial of final pension to the petitioner in this decided petition. The set cases cited for granting relief of similar nature to the petitioner. Yes, okay.
Well, I must be fair on one thing, So far as Nurul Islam case is concerned, although it was projected in the repetition that there is a similarity of the vigilance case and all and 4 years part, but the 4 years would attract only Nurul Islam case. That would not cover me because my dates are different. What covers me is this part. One line from the judgment. That is at page 62. The seriousness or gravity of the crimes charged against the petitioner cannot be a ground of denying him final pension payable to him under the law. Because the 4 years, in all fairness, my lord, that would be applicable so far as Nurul Islam is concerned. But in my case, it would not be applicable.
Okay.
This line is what I'm banking on.
Lawyer counsel for the petitioner has also submitted and has fairly submitted that the observation of the court in connection with clause C of Rule 21 of the Assam Services within bracket pension protection rules would not be applicable in the case of the petitioner.
But the last
under the facts of this case, where cognizance was already taken on 31/3/2012. However, he also submits that the observations made in paragraph 10 of the said order, whereby this court observed that the seriousness or gravity of the crimes charged against the petitioner cannot be a ground to deny him the final pension is relied upon by the young counsel for the petitioner. Next one. In order to demonstrate that the pendency of the criminal case against the petitioner would have to be construed to exclude the period of time which was during which the criminal proceeding had remained stayed. The General Counsel for the petitioner has placed reliance on the case of DPL Limited and others versus R. Sudhakar and others. You can give the citation.
Lordship, it is given 2004 supplementary to SCR 414.
Okay.
But the case number is there.
Within bracket 2004 bracket supplement SUPT within bracket 2 SCR 414. Equivalent to year 2004 SC 3606.
SC 3606.
It is submitted that although for the purpose of showing case pendency, a state case may still be reflected as a pending matter. But the Supreme Court has interpreted that if the proceedings have been stayed, which was the
Internal page 7.
Yeah, okay, as
The industrial reference would be set to be
as the-
pending only from 12/4
as
99.
the proceedings cannot continue. And the parties cannot oppose the court for any order. It would not be calculated as a, such period would not be calculated as a period during which the proceeding is pending. As there was no proceeding pending before the trial court. Next one. For contract on the Journalist Training Council for the Agriculture Department as well as the Additional Senior Method Debate. Both refer to the provision of Rule 21 of the Assam Services with the convention by those rules. The project that as the criminal trial is pending for adjudication, respondent authorities had a right to withhold disbursement of the final pension. So it is submitted that the final, the petitioner is getting the interim pension subject to finalization of the final pension of the petitioner. Full stop. It is also submitted that the financial implication of the scam in which the petitioner was charged is to the extent of several crore. Is to the extent of about, what is it called, 6 crores or 7 crores, 7 crore against supply of a particular item which is of substandard or inferior quality. Which was procured at a exorbitant rate. Next one. It is also submitted that the the Pension and Public Grievances Department by a notification dated 21/6/2012 had issued a directive to the effect that during the pendency of the departmental or judicial proceedings, no DCRG shall be paid to him until the conclusion of such proceedings and the issue of final orders thereon. Accordingly, it is submitted that the respondent authorities have likely withheld the pension of the petitioner. First.
But I've also stated about that there is no sanction till date. Prosecution.
That goes to the merit. We won't make a comment there.
And 21 on conclusion, I said. Yes.
Rules of Rule 21 of the Assam Services Pension within bracket pension, because those 1969 is expected below. On a perusal of this provision, it appears that the precondition of the withholding of pension is that the governor of Assam or an authorized officer acting in the name of the governor reserves the right of withholding the pension or any part thereof. Full stop. It is also observed that such right can be reserved. If in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service. In the present case in hand, there is no record of any departmental proceedings where the petitioner has been found guilty of grave misconduct, or there is any record of the petitioner having been held to be guilty in any judicial proceeding. As for the case presented by the petitioner, by an order dated 25/6/2013, passed in criminal SLP within bracket criminal number 5080/2013. The proceedings of special case number, you are accused in special case 19 or
Yes.
or 24. You are accused where?
This is FIR 204.
Vigilance case number?
It should be 19.
Hmm?
19.
It's a vigilance PS case number 2 of 2004, corresponding to
PS case number.
special case number 19 of 2012.
FIR 2 of 2004.
Post office.
19.
This court, in the case of Sri Satya Narayan Prasad Gupta, SCTY, NARAY Prasad Gupta, versus the state of Assam and others. Within bracket 2015, within bracket 4, bracket GLT 905, equivalent to within bracket 2015, that was 5 GLR 307. By referring to Rule 21 of the Assam Services within bracket pension, bracket close rules, had held that the state respondents, under the Assam Services within bracket pension, bracket close rules, 1969, have no power to withhold payment of the pension amount. To arrive at the said finding, This court had placed reliance on the provisions of Rule 43 within bracket B of the Bihar pension rules, as applicable to the state of Jharkhand, as well as to the judgment of the Supreme Court of India in the case of state of Jharkhand versus Jitendra Kumar Srivastav, SRI VSTVA, within bracket 2013 at 12 SCC 210. To hold that under Rule 43 within bracket B, the pension can be withheld only when a finding is recorded either in the departmental inquiry or judicial proceedings that the employee had committed grave misconduct in the discharge of his duty while in office. Stop. In this regard, this court had found the relevant provisions as material to the Rule 21 of the Assam Services within bracket pension, bracket rules, 1969. Full stop. In this case, there's no finding recorded by a judicial court that the petitioner has been found guilty of grave misconduct or negligence during the period of service rendered. Although the proceedings against the petition in the criminal case has commenced with taking of cognizance of the offence by order dated 31/3/2012. But according to the learned counsel of the petitioner, the period during which stay was operating cannot be said to be a period where the criminal proceeding is pending. Industrial Disputes Act, that's it. It has Industrial Disputes Act. Industrial Disputes Act. In page 6 of the judgment, the explanation is there. You see 33, it's a different picture altogether. Of the standing orders? 33 of the Industrial Disputes Act. My lord. The reference is not on the modalities of 33. Page 6 of the judgment, if Lordship takes up for a moment, what's the effect of stay? Not on the act or the scope of the act, what proceedings of any act. We take it to be in rem, the observation, right? Page 6 of the judgment. Yes. May I read? Which part? Page 6 in the case. Yes. In the case on hand, the situation is entirely different. The tribunal gets jurisdiction only on reference made by the government. When the operation of the very order of reference was stayed, the question of dispute pending before the tribunal did not arise inasmuch as the reference order itself stood suspended. So long as stay order was operating, it could not be said that a dispute was pending before the tribunal. Admittedly, when workmen were dismissed from service, stay order was operating. Where a single judge as well as the division bench of the High Court have proceeded on wrong footing, relying upon the decision of this court and Sri Chamundi Mopeds, etc., limited supra, that the order of reference was not wiped out by virtue of staying the operation of the order of reference. It is not the question as to whether the order of reference is wiped out, but the question is, what is the effect of staying the operation of the order of reference itself? Once the operation of order of reference is stayed, there is no question of dispute pending before the tribunal, so long as the said order remains in operation, because the reference precedes the dispute. To put it differently, a dispute could come up for adjudication by the tribunal pursuant to the order of reference only. If in a pending proceeding, operation of an order is stayed pending disposal of the main matter, such an appeal or revision, obviously the imprimatur order does not get quashed or wiped out, it only remains suspended. To put it, in the case of hand, the proceedings before it against the petition, politician is different because the order of reference is there. The reference is only referred to our industrial tribunal. If the reference is state, therefore there's no reference, there's no matter pending before the court. What I want different. It says
if in a pending proceeding or operation of order is stayed pending disposal of the main matter such as appeal or revision, generally. Obviously,
Criminal case is not so easy. Okay, I'll consider and pass on this.
but we are not on this pendency matter. I am saying it should be finally held.
But that's okay. We'll consider that.
This is 22/12 SCC 104 Lordship.
Just a moment.
2022.
D22.
12 SCC 104 Lordship. This is also, the Honorable Supreme Court has dismissed the full bench order of the Kerala High Court Lordship, where party name is Lordship, the Secretary, Local Self-Government Department and others versus K. Chandran, etc. Lordship, here also the High Court decision to allow the release of DCRG Lordship to the employees pending consideration of the criminal appeal Lordship.
No, this will be different because of the fact that in paragraph 4 of the order, we'll come to know that the accused petitioner was already sentenced in the case.
But Lordship, this is also that the Honorable Court has held that the Rule 3A of the Kerala Service Rule Lordship, this cannot be read in isolation and struck down the High Court's decision to allow the release of DCRG to the employees pending consideration of the criminal appeal.
Which paragraph?
Lordship, I'm just reading the headline, head notes only, Lordship.
Okay.
But
I'm on 21
It,
out guilty, Milo, and no more.
and conclusion, Lordship, para 42. We are thus of the view that the impugned judgment of the full bench of the Kerala High Court cannot be sustained, and it cannot be opined that DCRG would have to be released to the respondents pending consideration of the criminal appeals.
But not on the pension, Milo. I have to
Then
put it
we have,
No, not many.
please, we have not interrupted while you submit.
I have to interpret it because when we are interpreting and drawing on the section 33 interpretation, I
Lordship.
have to go through it.
But regardless of that, I confined to 21 to the found guilty.
Paid consideration. First, for the orders in chambers, let me examine that.
Lordship.
Lordship.
Okay. 23. Chamber.
23.
Basically, this matter is regard to payment of salary and promotion, Lordship. Lordship, despite several notices, the instructions are still awaited. So I pray for some accommodation, Lordship. A sorted may be given to me so that I can, Lordship, send some reminders to them. The affidavit will be required in this case, Lordship.
Lordship,
2014, she's not getting.
yes, your Lordship.
It's a long time.
Lordship. So what are the
The
reasons behind?
department, they have extracted my service as an Anganwadi worker, your Lordship.
Where is your order?
Lordship, it's at annexure 6,
Please give me the page number.
page 25, Lordship. I was allowed to officiate as an Anganwadi worker being eligible for promotion, Your Lordship. And in the last part of the order, it's reflected that this order must be regularized, Your Lordship.
What is your honorarium as Anganwadi helper?
As helper, it's only 3,250 rupees.
But then you can't get anything because the fact that in 26, they don't say that you get the salary of the officiating post. Unless that is granted, you are only officiating, you are only officiating as an Anganwadi worker. You'll not be entitled to that higher honorarium.
Lordship, in the last part of the order, it has been reflected, this order must be regularized after observing all necessary formalities and guidelines. Lordship, pursuant to this, all similarly, other similarly situated persons have also been promoted, regularly promoted, Your Lordship. It's at paragraph number 8.
You have a copy of the order, in such order?
No, Lordship. I have not annexed such orders, but there are specific pleadings in paragraph number 8.
Let him get in instructions. Lordship. It's 21 matter. We give you 7 days time, otherwise. Yes, Lordship. We put the respondents to notice that discussion would be allowed. We have Mrs. S. Barwa.
P. Hazarika.
Mrs. P. Hazarika, and counsel for the petitioner. So Mr. C.K.S. Barwa Ramed, government advocate, all raised for some more time to obtain instructions. Next paragraph. In this case, the petitioner was by an order dated 24/10/2014, issued by the CBPO, South Karimganj ICDS project. The petitioner was allowed to work as officiate Anganwadi worker against sanctioned vacant post in the number 119 Patel PATL Patel Nagar AWC under South Karimganj ICDS project. Which contains an observation that the said order must be regularized after observing all necessary formalities and guidelines issued by the government in the Social Welfare Department and getting approval from the Director, Social Welfare, Assam. Next, the counsel for the petitioner has submitted that under similar orders passed for different Anganwadi workers, their services have been regularized. Accordingly, by filing this repression under Article 26 of the Constitution of India, the petitioners are seeking a direction upon the respondent authorities for granting them pay of Anganwadi workers since 2014. And for regularization of their services in the said post. Next paragraph. The Commissioner Secretary to the Government of Assam, Social Welfare Department, within bracket, respondent number 1, and the Director of Social Welfare, within bracket, respondent number 2, I put to notice that in the event they fail to provide appropriate instructions to the learned government advocate. As notice of motion was issued by order dated 3/9/2021. Court shall presume that the respondents have admitted the claim of the petitioners and by invoking the doctrine of bound traverse, appropriate orders will be passed. Next one. This one, 19/7/2024. We are giving you more than sufficient time. Pass orders in the next date. What's the question?
24.
The Waters employee, my lord, retired on 31/12/2020, my lord, 2020. And my lord, he want to, my lord, get family, my lord, pension, he want to get pension, my lord. Already he has got some benefit, but his service was not regularized. It was, my lord, 1493. And this case is filed on the basis of the, my lord, paragraph 36 of the Prem Singh judgment, my lord. Here, my lord, I want to, my lord,
Which judgment?
Lordship.
Which judgment?
Prem Singh, my lord. Supreme Court full bench judgment, my lord, 2019 10 SCC 516. Paragraph 36, some question has been mentioned because he continued, my lord, as a workers employee 28 years, 7 months. He was, my lord,
What is the Supreme Court citation?
my lord, I am giving that. Prem Singh judgment. 2019 10 SCC 516.
2019?
10 SCC 516. Paragraph number 36. Another recent judgment, my lord, I'm
Just a moment. Uh, how do you say that this judgment is applicable in the present case in hand?
What's as
plain
employee,
saying-
my lord, that's why. And Vinod Kumar judgment, recent judgment
no.
is also there.
You have a copy of this judgment with you?
I have that.
You have this copy?
Yes,
Please come to paragraph 8.
yes, my lord. That's-
You see, you've seen paragraph 8.
Yes, my lord.
In paragraph 8, this Uttar Pradesh retirement benefit rules have been quoted,
Yes,
where there is a provision for the qualifying service, and it provides that whether the service is temporary or officiating.
yes,
So therefore, there is a service rules of Uttar Pradesh, which provides that even if there is an officiating service and then you have rendered particular years of service, then you will be entitled to the what you call be a pensionable service. So that is why that was extracted. You
For,
see,
for any particular project, if it is, my lord, entrusted any work,
No,
my lord, works
in
as.
Assam, you will have to show that there is a perimeter provision which permits the state government to add the officiating service or temporary service to be constituted as a service which is pensionable.
Yes, my lord. He was a electrical mystery, my lord.
No, that's okay.
Always required
But
because in the PMC, he
but
was.
you're referring to Prem Singh.
Yes, my
You
lord.
you must understand Prem Singh first. I think I have to raise this
Yes, my
High
lord.
Court reference, but this Prem Singh does not apply on the facts. This Uttar Pradesh rules, they are in a different footing.
And Vinod Kumar judgment, recent judgment, my lord, 24, I have written. That is also followed, my lord. He was accountant, accounts clerk. Paragraph 8. Will it be on another date, my lord?
In both Prem Singh and Vinod Kumar lordship, petitioners were regularized workers and employees. Here, his service has not been regularized. That is the basic
You
distinction.
see, this paragraph 2 will make it clear. That's why I was reading continuously this paragraph 2,
Yes, my lord.
and thereafter this paragraph 8.
Yes, my lord. I have
Here-
marked here.
Correct. Now that will make it clear. Mr. Nayak has made his points. I think we'll take it up some other day.
Yeah,
I
other
don't
day,
have
madam.
time today. You take back this. Let's say the possibility time matter could not be taken up today, this time, but let me forecast give a date. After rise, it will give the dates. Is any other interim orders to be extended?
Yes, my lord, in item number 34, Interim order is still returnable, that is stored.
34.
Just. Item number 44 for correction, in this case for correction of minor title, minor address, minor. That's small.
Item 44. 44 given the chamber.
Only for correction of the addresses.
Address of respondent number
Private response.
or the private respondents. Okay. I'll pass orders.
Well, item 34, interim continued, but date may be fixed mail after 2 weeks mail.
Oh, pass it.
Oh, it did. 34.
I need to mention item number 30, madam. This is the suspension matter, madam. Any date, madam, to see? 30. No, yeah, it's had to do. No.
It is a fair, madam, item number 27, the respondents have already considered, madam, the short date may be given. Well, item number,
You have to raise because otherwise.
item number